Welcome back, y'all. This one here, I'm going to get into the case, the Supreme Court ruling, and I'm going to point a few things out. A lot of y'all that have watched the Supreme Court ruling, you've noticed that in one part there, I think that it was Justice Lee, she said, well, these judges didn't owe these guys $13 million. They talked in the actual argument about not having the underlying security agreement. Okay, this we know to be totally bogus. The Supreme Court did have it. Matter of fact, even let's see, what was his name? Irving, the prosecutor. They had this. They had these contracts. When I say contract, I mean the conditional acceptance, the underlying security agreement. So this whole argument and what I argue, or what I stated in the demand letter, one of the things that I stated was that they had this and they withheld material information. And a lot of y'all that have read the conditional acceptance, you all know that there's a footnote in here. It's usually at the bottom of the very first page that says a public official is a fiduciary toward the public, including in the case of a judge, the litigants who appear before him, and if he deliberately conceals material information from them, he is guilty of fraud. That's U.S. versus Holster, 1987. Okay, so what did they do? They withheld material information. That's addressed, and that will be addressed in post-conviction. I'll get into that a little bit later in explaining post-conviction, maybe on the next video. But the first opinion that came out, and this is out of the 5 judges or justices, there's 3 of them that agreed. Majority rules. That's why nothing's been overturned. They wrote, the Uniform Commercial Code provides a mechanism for secured creditors to give notice to the world of their security interest in debtors' property as collateral for debt by filling out a form for a financing statement and posting it on their website for Tennessee's Secretary of the State. In this case, the system was weaponized. They're saying we weaponized the system. Okay, where have we heard that? Where have we heard that before? That's what Biden's doing with the DOJ. He's weaponizing them. Oh, so we are too. It's okay for Biden to weaponize them, but even if we were weaponizing them, then why wouldn't it be okay for us? That's something to consider. Also, we didn't weaponize anything. And in the end, that will show. And it goes on to say, all were done for the apparent purpose of vexing and harassing the victims. All the defendants were convicted of multiple counts of filing a lien without reasonable basis. So they're saying we didn't have a reasonable basis or a legal right to do what we did. And also, if you're familiar with the conditional acceptance in the footnote, usually the second to the last page, or the second to the last page. This is Snydash versus Family Finance Corporation. This is 1969. The ability to place a lien upon a man's property, such as to temporarily deprive him of its beneficial use without any judicial determination of probable cause, dates back not only to medieval England, but also Roman times. Okay, so they're saying that we had no legal basis to do what we did when you don't need it, folks. You don't need it. Snydash versus Family First is a United States Supreme Court ruling. It eventually went to the Supreme Court. So they're saying without a reasonable basis. And all through the argument, they talk about it. Or this opinion, the argument and the opinion, actually. If you read through it, you want to read through it, it's 20-some pages. It also says on page 3, paragraph 4, whatever the reason, none of the victims had business dealings or contractual relationships with any of the defendants. Okay? None of the victims owed money to any of the defendants. Nevertheless, all the victims were subject to the same treatment. One or more of the defendants indicated in a public record that the victim had underlying indebtedness totaling in the millions of dollars and claimed the defendants had a security interest in the victim's property as collateral for indebtedness. Okay, well, I've shown it before. I also put that in the document that we sent the Chief Justice, that in fact there was a debt. My ex-wife used it in bankruptcy. The federal courts in Greenville discharged the $4 million that I liened her for. They discharged that, and the United States Code says only provable debts can be discharged. If you owe me $500 and this is on a handshake, and I don't pay you, try and discharge that in bankruptcy. You can't do it. There has to be a contract. In order for my ex-wife to discharge the $4 million, there had to have been a contract. They had to show a contract, which they did. And what was that? That was the underlying security agreement that the Supreme Court said that they weren't aware of. When in fact everybody was aware of it from the TBI at the beginning. Tim Burchett, you heard me read that in a previous video. He said he had no business dealings with me. And then he read the contract with the contract number. That's even in this document, this ruling, that there is a contract. And it also goes on to say on page 4, this is the kicker. Over the course of the trial, Mr. Burton identified 102 different UCC1s the defendants filed in the Secretary of the State's office. Each identification was done in much the same way, with Mr. Burton's testifying as to the name of the filer, the listed debtor, the listed security party, and the description of the collateral. In each instance, one of the defendants was listed as the filer and secured party. Okay, here's the next sentence. Listen to this closely. Generally, each of the UCC1 descriptions of collateral included a claim of lien based on a concocted contract, okay, or lien in the amount of anywhere between $4 and $12 million, the money in the account, or in lieu of account, whatever currency is prescribed as lawful currency, as all the public debts, public and private, in the county in which the claim was executed. That's all in on line 12. The maximum principal indebtedness for Tennessee recording tax purposes section of each UCC1 listed $0. Okay, let me back this up a minute. Generally, each UCC1's description of the collateral included a claim of lien based on a concocted contract. Concocted, according to Webster's. To digest. To prepare from crude materials as food. From the thesaurus, concocted. Cook up, devise, dream up, formulate, frame, hatch up, vamp up. Okay, so what is that? Those are verbs. That means there's something real. Concocted isn't something that is fictitious. It isn't even there. You don't concoct something that's invisible. So they're actually admitting in this decision that there was a contract. Call it a concocted one, call it one of no legal value, whatever you want to call it. It's still, you still had this. And Justice Lee, who concurred with the majority, said we didn't have it. They had it. And this is how I know they had it. After the Supreme Court ruling, the lawyer who usurped Ron, he was the first one that argued in the Supreme Court. His name was Russ. He sent Ron was expecting something from me that I sent him, that I stamped legal mail on so that he would get it. These prisons are bad to destroy mail that I send to my friends. First they read it, and then they destroy it and they don't get it. So, because they know what we're doing. They want to foul this. They'll commit crimes. The state will commit crimes to get what they want. And there's plenty of proof of that. But he was expecting something from me. So when he got the memo to come down to the mailroom to get his legal mail, he was thinking it was from me. But instead it was from Russ. With a letter stating, I'm no longer your attorney. Here's everything that my office had. This guy was with Ron for most of the whole thing. So Ron gets this big packet of legal stuff, and inside there, it's the conditional acceptances. Mine, one of his. I think he had one from Lee Cromwell too. They had these contracts. Every one of these people, that, including my ex-wife, we don't have no business arrangement with them, including a United States congressman. I don't have any contract with him or any business arrangement with him, although I did get something in the mail, which I turned over to the county attorney, who in turn turned it over to the TBI. They had this, and this contract was withheld. So, and then they're admitting to it, a concocted contract. Now, a lot of people have read this. A lot of people have read it and, got out here, tried to slam, oh, he's in prison, and, oh, he's under the jail, he ain't ever getting out, and, people have said all this stuff solely by reading the first one. Now, they haven't read this one. A lot of folks, a few have, and it was actually brought to my attention. It's an honest mistake in most cases, because I read the first one without reading the second one. I thought that they had just messed up and posted it twice on their website. And while I was reading through the first one, a friend of mine called and said, hey, man, I read your thing, man. I mean, there's people calling me, telling me about it before I even knew it. Those are people out there who support what it is we're doing. So I'm going to read parts of this, a majority of this, because y'all need to know the dissenting opinion. Okay? This is the dissenting opinion. It's only about, 6 pages, not even 6 pages. And this was written by Holly Kirby. She's one justice that you're familiar with if you've watched the video. The other one's Sarah Campbell. She's the new one. That was her first time sitting on the bench. From April. This is April the 6th. Anyway, this is when this one went down. Holly Kirby, Justice, with whom Sarah K. Campbell Justice joined, concurring in part and dissenting in part. I concur in the majority of conclusions that the evidence was sufficient to support the defendant's convictions of forgery. I agree with the majority that the defendant's conduct fits within the statutory definition of forgery under Tennessee Code Annotated, Section 39-14-114 B1B. I write separately to dissent from the majority conclusion that the evidence was sufficient to support sentencing the defendants for forgery as a Class A felony. 20 years, y'all. That's where the 20 years comes from. I'll get into the other 2-year conviction and how that's gone probably in the next video. Based on the text of the applicable statute, I would hold that the evidence was not sufficient to support the jury's finding that the UCC-1s had a fair market value of at least $250,000. And that's footnoted. In their brief to the court, defendants Hauser and Usinger argued that the evidence was insufficient to support the jury's determination of value. Defendant Cooper and Cromwell previously made similar arguments in their motion for a new trial. During the motion for the new trial, my ex-wife was filing bankruptcy. Oh no, man, what's going on here? And see, in the trial, they were all told how they could get these UCC-1s lifted. My ex-wife must have not have been paying attention because she went out and filed it in her bankruptcy, and they discharged it. Folks, I'm telling you right now that the conditional acceptance is the underlying security agreement, and it's genuine. The federal courts have saying that it's genuine. There's 2 United States codes. One is you can't schedule a fraudulent lien for discharge. Okay, it's not fraudulent. According to the state of Tennessee, it is. According to the federal courts, it's not. Only provable debts can be discharged. Oopsie, let's discharge this. Now it's a provable debt. I would reverse the holding of the Court of Criminal Appeals to the value associated with the defendant's forgery conviction. 2 of these justices said that this wasn't a forgery of $250,000. Matter of fact, it's a forgery. If they're saying it is a forgery, but they're saying it's a forgery with zero value. Zero value would have made it a Class E felony. $0 to $50 of a forgery is a Class E felony. 2 years. Well-established standards for reviewing the sufficiency of evidence consists of 2 distinct steps. Listen to how this justice busted the rest of them out. Our standard for reviewing the sufficiency of evidence underlying criminal convictions is well established. First, we examine the relevant statute or statutes in order to determine the elements that the state must prove to establish the offense. Next, we analyze the evidence admitted at trial in order to determine whether each of the elements is supported by adequate proof. That's State versus Stevens. Most all these are Tennessee cases. Tennessee 2017. Emphasis added. State versus Smith 2014. As conducting statutory interpretations of offenses, elements before conducting sufficiency reviews. State versus Gentry 2017, stating that to be, we determine the statutory elements the state must prove, citing Stevens. State versus Mitchell, Tennessee 2019. We must evaluate the proof in light of the elements of the crime, as recognizing that the first step of the sufficiency review is to examine the relevant statute in order to determine the elements of the offense that must be proven by the prosecution beyond a reasonable doubt. Okay, that's the first thing you got to do. It is well established, then, that we must analyze the statutory elements before we evaluate the proof of sufficiency. Here, the majority skips over these steps entirely. She's telling them that, look, guys, look, fellow justices and Chief Justice, the majority skipped over the steps entirely. Instead, it quotes the statute that defines value, reciting the pattern jury instructions on valuation, and then goes straight to its conclusion that the evidence is sufficient without ever having determined the element of evaluation the state must prove. She's pulling no stops with her comrades that sit up there on the bench. Respectfully, that's contrary to our own case law. Our jurisprudence requires us to first review the permanent statutes to determine the statutory element, as explained below. Analyzing the statutory elements in this case necessarily leads to the conclusion that the evidence here cannot support the sentencing the defendants of forgery for a Class A felony. The state argued the value of the UCC-1s to grade the forgery offense is the amount in the description of collateral, because that establishes the property in which the defendants claimed as possessory interest. Never once was possessory interest used in our documents. Never once was it even used in the trial. Only in appeals do they start calling it a possessory interest. A possessory interest is if I lien you and I say you owe me money and I lien your tractor. Okay, I keep your tractor. You don't get to use your tractor until you pay me back. That's possessory interest. So if it was possessory interest, we would have to hold your $4 million or your $12 million until you paid us your $4 million or $12 million. They've been using this wrong since the beginning. It's not a possessory interest. Never have we possessed anything. As noted by the majority, the collateral description in the UCC-1s were intended to convey an impression that the victims owed the defendants millions of dollars. Mr. Birdsell's testimony about defendants Cooper's comments, well, that's $4 million, would be a basis for the jury to infer that the defendant believed the filing of UCC-1s would result in their obtaining money in some amount from the victim. Actually, it's a victim's trust. None of the defendants here received any money from the victims, but the state need not prove they actually obtained property or services to be convicted of the offense of forgery. State versus Odom. And it goes on to explain the Odom case. I'm not going to read that. Then, in that sense, then the apparent value of property or services is sufficient. In Odom, the document was a negotiable instrument, which, if authenticated, can be used to obtain money. The amount written on the check is the amount of money the defendant could have obtained had she cashed the check, the apparent value of the forged check. We couldn't have took these UCC-1s and walked into a bank and said, this is a negotiable instrument. It was the United States Treasury that made it a negotiable instrument. They weren't until we sent them to them. That's why we used the UCC-3. We assigned it to the Treasury so the Treasury could create a negotiable instrument based on the claim of lien. Even then, the claim of lien is still not negotiable. The Treasury is going to create a negotiable instrument based on the UCC-1. Here, the jury was instructed to find apparent fair market value of the UCC1s at the time and place of the offense. I agree that the statutory definition of value at issue is the appeal, or in the appeal is the fair market value of the property or service at the time and place of the offense. It's talking about the check. And then it's into the more arguing into the rest of it. Paragraph 4 on page 3 is about the Tennessee Code Annotated 3911-106A39 and 3911-104 and a couple of opinions about fair market value. Important to this appeal, forgery is graded under the same statute that grades theft offenses. The statute punishes theft of property or services as a Class A felony if the value of the property or services obtained is $250,000 or more. Like with us, they're saying if you steal something, that's the value. They charge you with the felonies based on that for theft or forgery. The term obtain is statutorily defined. This is what obtain means. If they were possessory, then we would have obtained them. Obtain means bring about to transfer or purported transfer of property or of a legally recognized interest in property, whether to the defense or another, or secure the performance of service. Thus, although we have construed the forgery statute as not requiring the defendant to actually obtain property or service, these statutes show valuation of forgery is not divorced from the concept of obtaining property or services. Reading these statutes together, as we must, they show that we have that to have fair market value, the forged document, if authentic, must at least be capable of facilitating or bringing about the transfer of services, property, or legally recognized interest in property. Tennessee Code Annotated 3911-106A39AI. Applying the statutory elements, for example, in Odom, the amount on the face of the check in Odom presented its fair market value because the check was a negotiable instrument. And it goes on to talk about what a negotiable instrument is by Black's Law. A negotiable instrument is payable on demand or at a defined time. So, if authentic, the check was capable of bringing about or transfer the amount of money that was its apparent fair market value. Similar in State versus Finch, the Intermediate Appellate Court valued forged receipt, Tennessee Criminal Appellant 3, 2013. The defendant argued the receipt had no apparent value. The Finch court disagreed because a buyer, upon returning a receipt to the seller, may receive a refund of money at the store credits or in good kind. That's like what Emma was saying. She was saying that you can't take this UCC1 and take it back anywhere and get money for it, like a receipt. It's more of a hold the date. It's not the actual a receipt. You leave in the store, let me see your receipt. They want to see what you paid for it, what you own, what belongs to you. Now, if something's not right about it, you can bring it back. But you better have the receipt if you want money, or Walmart's going to give you a gift card on the amount just because it's got their code on it. Okay, and then here the state had to show that the forged UCC1s, if authentic, could facilitate or bring about the transfer of at least $250,000. In the defendant's trial, Mr. Burton described the UCC1s to the jury, where they are posted on the Secretary of the State's website, how they are filed or how they're filled out, what information they contain, and importantly, their purpose. Mr. Burton's description of UCC1s described UCC1s only as a financing statement used to serve notice to the world that the person who filed the UCC1 claims an interest in the debtor's property as collateral for the debt referenced in the statement. And then there's a footnote. In fact, the state's witness, Mr. Burton, also testified UCC1s were only a form of notice. Mr. Burton was asked, to be clear, when I was filing the UCC1 financing statement, that in of itself does not create a creditor-debtor relationship, ? Mr. Burton responded, that's my understanding. Mr. Burton was then asked if it's a notice of relationship? ? Mr. Burton again responded, that's my understanding. At no point did Mr. Burton describe UCC1s as a negotiable instrument or any other type of document that can be used to bring about the transfer of money and property, a legally recognized interest in property, or anything else. Indeed, there is no evidence in the record that would support a finding that the fraudulent UCC1s, if authentic, could have been used to obtain anything. Nor could the state offer such evidence. The purpose of the UCC1's financing statement is simply to prove sufficient notice to a third party to instigate further inquiries. Regional Bank and versus Bricks Contractors LLC, 2011. Tennessee commercial law governing financing statements expressly notes the UCC itself indicates merely that a person may have a security interest in the collateral indicated. Further inquiry for this party's concern will be necessary to disclose the complete state of affairs. Tennessee Code Annotated 47-9-502, Committee 2, 2018, Supplement 2020. UCC1s are only a form of notice. They cannot be said to have a readily ascertainable fair market value, apparent or otherwise. See Tennessee Code Annotated 39-11-106A 39AI. Here the majority ignores the imperative to examine the relative statutes in order to determine the element that the state must prove to establish valuation. Stevens, 521, Southwest 3rd at page 723 and 724. To prove valuation of at least $250,000, the statute requires the state to prove that the forged UCC1s, if authenticated, could facilitate the bringing about or the transfer of at least $250,000. It did not. We're about to the end here, folks. Absent such evidence, I would hold that the UCC1s in this case have no readily ascertainable apparent fair market value under Tennessee Code Annotated 39-11-106A 39AI. Consequently, they should be considered documents whose value cannot be ascertained. See Tennessee Code Annotated 39-11-106A 39C. I would reverse the holding of the Court of Criminal Appeals as to the value associated with the defendant's forgery conviction and remand the case to the trial court to resentence the defendant's forgery conviction as a Class E felony. See Tennessee Code Annotated 3914-114C. In no event shall forgery be less than a Class E felony. Signed by Holly Kirby, Justice. Okay? Now look, y'all. This isn't over. When this justice gets this other document, and I'll talk about it in the next video, when they get this document, they're going to have one option, and that is to meet our terms, to dismiss all of this, or this goes back for post-conviction relief. The letter that I sent them, or the document, the demand, it's a demand letter basically is what it is, that I sent them, is the birth of the post-conviction relief. In post-conviction relief, well, I may talk about that in the next video. Other than that, y'all, I'll be right back with another one.